Okay, now they should be okay. Can you see the screen?
Yes.
Okay, perfect. So today our focus is going to be on the regulation of AI, focusing on particular on the AI Act. In the in the future session, we are going to consider other legal instruments that are relevant to the regulation of AI, such as in particular the GDPR, the Data Protection Regulation. You must know, in any case, that the AI is not coming in a legal vacuum. There are a lot of legal rules that are relevant, general legal rules. We have the rules in the criminal code that punish any kind of crimes that can be committed with the help of AI. We have the rules in the civil code, such as the rules that establish compensation for damages, the rules of contracts. All these rules apply also to AI, to the harm caused by AI, to the engagements that are entered into in order to develop AI systems. There are the rule of administrative law that govern how administrative acts are made, and therefore the use of AI within the public structures. In particular, the most relevant kind of rules that still, I think, are the most relevant for the purpose of the individual persons, individual citizens that are facing AIs, are the rule included in the General Data Protection Regulation. But this we are going to address in a next session. So let us say something about, today we focus anyway on the AI Act and on the process that led to the production of the AI Act. AI has, as you know, has gone through ups and downs. We had in the 50s the era in which a few heuristics were supposed to address any problem. Then there was a disillusion. Then we had the era of the expert systems, when it was assumed that it was possible to put all relevant knowledge in the form of a set of rules and concepts, ontologies, and have a system use this knowledge to address any problem. Then this didn't work at all. And then we had, and we are still in the era of machine learning, where we entrust to machines not only the purpose of using knowledge that is provided by human, but the purpose also of building a knowledge model that can be used to address issues, solve problems, to engage in various activities. And we had the era of predictive AI, when we give an AI system a set of information, and the system infers further information. Maybe in the medical domain, the system makes a diagnosis or provides a prognosis, but also there are instances in which there is a direct impact on individuals, such as when a system infers how much the creditworthiness of a person, or whether a person is suitable or not for a certain job. There has been the merge between AI and the internet, when the internet provides a vast amount of machine-readable knowledge that can be used in the era of machine learning to train an AI systems. And in this context, some worries have started to emerge. There is the worry of the so-called surveillance capitalism. So when AI is able to use any kind of data to train a system, there is a pressure to collect as much data as possible, in particular over individuals. The phenomenon of online surveillance has not emerged with AI, but certainly AI has given new impetus to it, as AI makes us able to use knowledge in order to make prediction also about individual behavior. Consider the case of creditworthiness, of suitability for a job, of a prediction concerning the health of an individual. And this ability of AI gives impetus to the collection of more and more data. The driving force for a long time has been the advertising, where AI has been used to send targeted ads to individuals, this providing a big pressure to collect more and more data and monitoring online and offline behavior. But this kind of mechanism can be extended above, so to other domains. Here in this slide, you can see the general issue of the surveillance, the collection of data that enable to make predictions concerning individual behavior. Again, consider advertising, but this is just a domain. And then this prediction can be sold so that data that enables to influence individual behavior becomes a new merchandise that can be sold. And this is the basic idea that is developed by Shoshana Zuboff in her very successful book, The Age of Surveillance Capitalism, how the market expands to cover personal data and the possibility to exercise influence over individuals. We had issues of fairness, discrimination, such as in the famous Dutch tax authority case, which was a very important case taking place in the Netherlands, where a system was built to identify possible violations of social security law, in particular to identify individuals who had received undue benefits, in particular child benefits. And this system was built in such a way that as soon as a person was identified as a probable violator, somebody who was engaging in this kind of fraud, you may say, to the social benefit system, a request to pay within a few days was sent. And a lot of families were put in a situation of serious distress because this was merely a kind of probabilistic prediction. And even people who were fully compliant with the law were sent this request to pay, and many poor families were unable to respond and even to pay what was, to challenge this request and then to pay what was required for them. So there was a big problem. Immigrant and poor families were in particularly targeted, serious problems that had an impact on a vast number of individuals and led also, I think, to the fall of the Dutch government of the time. There is a problem of AI systems reflecting the whole of society, not just focusing on larger or wealthier groups, so excluding certain communities. There is the problem of AI system causing harm to people, even we may say that in many cases AI also prevents harm from happening. And the book that was influential was this book of Weapons of Mass Destruction, which focused on the negative impact that algorithmic prediction may have over the individuals that are targeted by such prediction. So there is this kind of unfairness issues, but also in general this pressure towards surveillance and prediction manipulation over individuals. In recent times, we had also a new, a different challenge that has emerged. We had the explosion recently of so-called generative AI. A generative AI poses an additional set of challenges to individuals and society. Challenges that go from the generation of disinformation, not only using AI for targeting false or misleading messages in order to influence people, but also generating through generative AI individualized messages. And then there is the problem of what happens to human creativity when human works, the whole of human cultures, is processed in order to produce new content that potentially enters into competition with the content produced by human. And there is the problem of the future of work when humans may be substituted by machine or relegated in a kind of servient position in relation to machines. So a host of challenges coming through AI. The European law has been Europe. There's been a worldwide debate on how to deal with AI, and for quite some years, this debate has been considered as an ethical debate, leading to the definition of values, of principles, but without a kind of compulsory institutional mechanism for defining such a principle, translating them into rules, and then having these rules also enforced through an enforcement mechanism, including authorities and sanctions, in order to make them complied with. And this is the transition from ethics into the law. We had a long process dealing with the governance, the regulation of AI in the European Union. It started in 2017. We had a resolution by the European Parliament. Then in 2018, then we had also the opinion by the European Economic and Social Committees. Then we had communication on the AI strategy. And then a high-level expert group was created with the task of defining ethics guideline on trustworthy AI, an AI which is human-centered and that deserves to be trusted upon by individual. I will say something more on that. Then we had the European Commission's communication on building trust in human-centric AI, policy and investment recommendation. We had a phase of consultation with stakeholders. We had also a white paper on liability of AI system that led to a proposal of a directive, but this at the moment is not going on, so I will not. The purpose of the liability directive would be to make it easier to establish the liability on the side of AI system when somebody is damaged as a consequence of the operation of an AI system. But this is not we had the very important document on trustworthy AI, which identified some key principles to be complied with in the development and deployment of AI system. We are still at the level of ethics. This document referred, I think you already had an introduction to the ethics of AI, so I will not spend much time on that. But this document refers to the famous principles of bioethics that were originally contained in a book by Beauchamp, what is the name of the other? Doesn't come to my mind. Anyway, the principle of bioethics that includes the principles of the respect for autonomy. Then in bioethics, the principle of bioethics, you have two principles that here are merged. Maybe that is the idea of beneficence, trying to do something that is good, that increases the well-being of individuals and society. And on the other hand, the principle of non-maleficence, don't do something that causes harm. Here only harm is mentioned, which is not good, I think, because the ethics of AI is not limited to the negative aspect of preventing harm, also includes the requirement that we engage in deploying AI and in using it in such a way as to improve the situation in our society, to deliver new good to individuals and society. Anyway, beneficence plus non-maleficence, number two. And three, we have the principle of justice, of fairness, that requires that the benefits of provided by AI are shared within society, and that the AI systems themselves do not produce discriminatory discriminatory outcome, producing outcomes that have negative impacts for certain individuals of group without any valuable justification for that. In addition to the principle of justice or fairness, we have the idea of explicability, which is the new principle that is added to those of bioethical principle, the four bioethical principles. There is also an additional one. So four bioethical principles, because the bioethical principles include autonomy, beneficence, non-maleficence, which here are merged into the idea of prevention of harm. And then there is justice here translated into fairness. And then the new principle is the idea of explicability, that is, an AI system should be as much as possible transparent to its users, and also to society, should be able to understand how, why and how a system works, and also, at least to the extent that this is possible, this principle is a kind of a challenge, should be able to be given explanation of why a certain outcome has been provided by the system, especially when the outcome is a negative one for the individuals concerned. These principles are further being analyzed and developed into various criteria to be complied with. And one of these criteria is the idea of accountability. There should be mechanisms that ensure responsibility and accountability for AI system and their outcome, both before and after their development, deployment, and use. So it should be possible to that somebody is in charge of the system, and that this person, this institution are accountable. We have somebody to whom we may ask why a system doesn't work appropriately, and some measure can be taken also against the responsible ones if something bad has happened. So we need to be able to identify the person who will be able to give a convincing answer to the questions, or otherwise be subject to the consequences of their failure to adopt appropriate precautions. If there are any questions, I'm happy to stop. And then we come to the AI Act. The AI Act was proposed by the Commission. We had a text coming out by the Commission. And the European Union had a very ambitious idea. So Europe wanted to be the first region, the first country, but the first region in the world where a comprehensive regulation of AI is provided. The kind of model for this was the General Data Protection Regulation, the GDPR, that was adopted a few years ago. And the GDPR somehow has been adopted in Europe, but has also succeeded to some extent to become also a global standard. Various countries in the world have adopted regulations that are similar to the GDPR. The United States has not, but South American countries have, Japan, Australia have, also in other parts of the world, the example of the GDPR have been followed. So the European Union wanted somehow, hopes somehow to set, to provide an adequate regulation in Europe to protect European citizens, European values from the dangers of AI, but also they want to establish a kind of global standard. Whether this will happen is, we may doubt that whether this will really happen, but I think this was one of the general idea. The AI Act is a very complex regulation. We had a long text produced by the Commission, but then the Parliament intervened with more than 700 modification of the text originally proposed by the Commission. Also the Council intervened. Maybe you don't know, I don't know how many of you are lawyers, but there is a complex legislative procedure for at the European level, where the Commission has to make a proposal, and then the proposal is sent to the Parliament and to the Council. The Parliament includes the members of Parliament that are elected by the European citizens, while the Council includes the representatives of the member states, one for each member state. And there is a process where the text travels between the Parliament and the Council until an agreement is found. When the same text is approved by the two bodies, then it can be enacted and come into force. This is what happened with the AI Act, which was subject to a lot of changes. In particular, the intervention by the Parliament was quite massive. And in the end, we have a text which is very long. There is a kind of 150 pages, including a vast number of articles, long and complex ones, annexes, and this document, the AI Act, is it's not, I would say, if you want to try to engage with it, you can try to read it and you will find quite heavy. It's a text that is dense with technicalities in addition to legal requirements. So it's not so technologically neutral, but it builds upon the features of AI system of today. And there are discussions whether this was really the real approach, but the best approach. But anyway, this is what we have, and we have to try to make the best possible use of this very long and complex legal document. The AI Act is based on the idea of two ideas. The idea that we should have a kind of risk-based regulation. What does it mean, a risk-based regulation? I think we can dissect the two main meanings of this concept. That the purpose of the legislation is not to intervene after harm occurs, but to be preventive, to regulate the products, the AI system, before they are put in the market, so that these systems are only put in the market when their risks have been prevented and or mitigated at least, so that harm should not happen. And then the second idea is that different rules should be in place, and more stringent rules should be put on the system that present higher risk, and milder rules on the systems for which this is not the case. So on the one hand, preventing risks rather than punishing behavior that has caused damage, and in the second sense, adopting an approach differentiating different kind of system and imposing more stringent rules in those systems that are more likely to cause harm, that present higher risks. A feature of the AI Act, on which I will say something later, is that this concept of preventing risks has a broader scope than it is usually the case. So if you consider other risk-based regulation that are aimed at preventing risks, consider the regulation on medical devices or the regulation on toys, chemical products. In these cases, basically the risks to be avoided are the risk to security, safety of individuals, health and safety, maybe also protection of the environment. In the case of the AI Act, the concept of risk is broadened. It covers obviously health, safety and environment, but it expands also to risks for fundamental rights and fundamental values. Fundamental rights are the rights that are established in the European Charter of Fundamental Rights, which include rights such as privacy, data protection, freedom of expression, freedom of association, non-discrimination, right of workers, and the fundamental values that can be found in the European treaties are the ideas of such as the principle of democracy and the principle of the rule of law. So when examining whether the risk presented by an AI system are acceptable, not only health and safety have to be taken into account, but also this broader context. How does the AI Act approach this problem? And as we shall see, the idea is to distinguish different kind of systems according to their function and the domain in which they are meant to be deployed. And therefore, there are some systems that are assumed to inevitably cause unacceptable risks, to have inevitably serious negative effects, and these systems are prohibited. Then there are systems that are considered to possibly have high risks, and these systems are not prohibited, but requirement are set up that they have to respect. We are going to see what these requirements are. And this system can be put on the market only when it has been established that whatever risks they present, this risk has been minimized, mitigated, and that they are acceptable with regard to the benefit that the system is going to deliver. And then there are some general transparency requirements that concern mainly the idea that we should be able to distinguish synthetic messages, artificial generated, and synthetic content from what is produced by human. This to avoid that we lose the ability to distinguish artificial illusion, artificial images, and also artificial agents from human one. There is a conformity assessment for high-risk systems. There is an enforcement mechanism. So if the requirements are not respected or an AI system causes any harm, there is the possibility of having the intervention by competent authority and sanctions, and a governance structure involving different bodies is established at the European and the national level. This is a bit, this slide is a bit old. As you see, this is the path that has already been taken, and the AI Act has entered into force, if I remember well, on 2 August 2024. But some important provisions of the Act are going to enter into force only at the later stage. In particular, the most important provisions, those concerning, I think that on February this year, the prohibition of systems that present unacceptable risks has already come into force. So these systems are already prohibited in the European Union. But the most important rules, that is the rules on high-risk system, are going to come into force only at a later time, that is 2 years after the entry into force of the, they're going to come into effect 2 years after the entry into force of the regulation, that is on 2 August, I think, 2026. So companies have been given a length of time during which they should take initiatives in order to be ready for the time in which all requirements of the AI Act will come into effect. And the Commission is actively engaging now to induce companies to take steps already now in order to start to comply with the rules in the AI Act, even before that these rules become legally binding, so that when we are in 2026, the company are able to put in the market product that comply with the act. So this is a bit the kind of context in which we are. If you have any questions, I'm happy to answer it. Please don't be afraid of interrupting me. I cannot see the chat, so if you have any question, please use your voice. I will be able to hear you. Okay, so as I have said, the idea of risk-based regulation, in particular, the European Union has a lot of experience in regulating dangerous or risky products, and they have applied this approach also to AI. So the focus is on AI systems as products that should be put on the market only when their risks are acceptable, and they are subject to a preventive controls meant to prevent harm rather than intervening after when harm has already taken place. There are technical requirements, and the AI Act is dense of technical requirements, maybe to an excessive level, but okay, you may criticize a legislative document, but once it is there, we need to do our best to have a sensible application of it. And then there is a conformity assessment, which means that before the system is put on the market, there is an assessment to determine whether the requirement of the Act has been complied with regard to that system, and whether the risks of the system are acceptable. If the evaluation is positive, then the system can go on the market with the European Union label. Another aspect, I already mentioned it, the risks to be taken care are not just safety, health, safety, and environment, but include fundamental rights and social values, fundamental values such as democracy and the rule of law. This makes the assessment much more difficult, broader than the traditional assessment that you may have with regard to toys or medical devices. It is important also to consider that this approach, sorry, just a second. Ugo sta facendo lezione, sentiamo tra un'oretta, scusa. This assessment, okay, that the basic idea of the AI Act, it is a kind of administrative regulation. It does not confer directly rights to individuals. So as an individual, you cannot request that the requirement in the Act as applied to the products with which you interact. Obviously, if you suffer a damage as a consequence of the violation of some rules in the Act, you may be able to obtain compensation because this violation may consist in a negligent or behavior by the producer of the product, but you are not an addressee of these rules, and you do not have standing in front of a judge to require compliance with these rules. This has been a choice in the Act. Some authors have argued, some lawyers have argued that this is a wrong choice individuals and the social society, such as consumers. Consumers, what is happening now? I don't know, there is a noise. Consumers Association. I don't know what is happening, sorry. Notification, include alert, icon badges.
Someone named Chen Qingqing sending some noise. If someone has rights to mute, okay, she or he muted, sorry.
It's okay now. Okay, so there is a discussion on this, and it has been argued that people should have individuals that are affected by an AI system or that have an interest in its compliance should have a right to engage in, to have appropriate legal remedies to require the enforcement of the act against those, the developers or the deployers that fail to respect the rules in the AI Act. But this is an open discussion. From what we can see now, there is no new right that is granted to individuals by the AI Act and the AI. So just to give you an example, in the data protection regulation, it is different because if you are a data subject, a person whose data is processed, you have rights against the data controllers, those who are collecting and processing your data. You may request that the processing is stopped. You may go in front of a data protection authority claiming that your data is processed unlawfully or requiring your data, the processing of your data to be terminated. This is not the case with regard to the, you may claim that the individual decision adopted on the basis of your data are unlawful, adopted without the condition established in Article 22 of the GDPR. This is not the case for the AI Act. It is the compliance of the AI Act is depends on the interaction between the competent authorities and the developer and deployers of AI applications. But we will see what will happen in the future. Maybe there will be an evolution of the law giving more a larger role to the individuals that are concerned by the effect, by the impacts of AI systems. With regard to the individual position of individuals in relation to AI application that concerns them, imagine that I am a person whose which has been the object of assessment of creditworthiness and consequently denied a loan. I can rely on the GDPR in order to trigger an assessment of the way in which my data has been processed in giving me a loan if I believe that I have been wrongly evaluated. But then I have to rely on the GDPR. I am not supposed to rely on the AI Act. And similarly, if I am an individual who has been denied a job and I believe that the AI system that has evaluated my application has discriminated me or treated me unfairly, again, I should use the GDPR, relying on Article 22 of the GDPR that addresses automatic decision making rather than on the AI Act. But this is something that we will see what will happen when the AI Act will fully come into effect. Okay, now we go into the content of the Act, and we start with Article 3, that 3 of the Act, that I should have something also on to what systems does the AI Act apply? For instance, if you are now interacting with, I don't know, ChatGPT or with any other kind of system that is located in the United States, does the AI Act apply to you since the processing is taking place in the United States? And the answer is yes, because as it was for the GDPR, also the AI Act concerns applies to those, doesn't look at where the processing of the data is done, but rather on where is the user, where is the system being deployed. But let us go at the definitions, and in particular, we focus now on Article 3, which provides the key definition of the whole Act. What is an AI system? And this is a definition which is really a challenge. It is very hard to define with precision what is an AI system. We can say that an AI system is a system that does something which requires intelligence, but then we have to face the notion of intelligence while he's making, I don't know, simple mathematical calculations, not an exercise in intelligence. We may say that an AI system does something, and then what does it mean to be intelligent? Can a machine be intelligent at all? You may say that an AI system is a system that does something that would require intelligence if done by humans, but again, we have to face the definition of what intelligence is. Many of the activities that humans and even animals do, such as identifying objects moving on a cluttered terrain or in a complex scene, require, it's very difficult to be automated. They require intelligence, even if we don't associate it with intelligence. In the proposal by the Commission, the notion of an AI system was linked to specific technologies. And that proposal focused on the idea of knowledge representation, of symbolic AI, and also on the idea of machine learning and statistics. The final version of the AI Act changed the definition and was inspired, I think, by a similar definition to be found in the OCDE, in the Organization for Economic Cooperation. And we have this definition. The AI system means a machine-based system. This is fine. So it's not a biological system. Designed to operate with varying levels of autonomy. So here, varying level of autonomies, what does it mean varying? From 0 to infinity, or is there a definite level where the autonomy starts being sufficient for a system to be an instance of an artificial intelligent one? That may exhibit adaptiveness after deployment. This is the idea of learning after deployment, but this is also a possible feature of a system, not a necessary one. So for instance, a system that can learn after deployment, you may consider those systems that work on the basis of so-called reinforcement learning. They get a feedback from the environment and then they adapt to the feedback. For instance, a system for sending targeted advertising, if the user clicks on the ad sent by the system, this is good, and the system learns to replicate the kind of behavior that, with regard to a particular kind of user, led to the clicking. And this learning that goes on as the system is used may be considered a kind of adaptiveness. For explicit or implicit objective, again, explicit objectives, but also objectives that are implicit, also nothing clear, infers from the input it receives how to generate output, such as predictions. So here we are in the domain of the predictive AI. You give the system some items of information, and the system infers further information. Imagine a system that does medical diagnosis. The system looks at a scan of the human body and makes a prediction of that the person has a certain kind of illness. You must consider in this regard that in the AI domain, we speak of prediction not only when the system tells us something about the future, but also when the system tells us something about the present. So not only when the system predicts that a person is going to have a certain illness in the future, but also when the system predicts that the person has now a certain kind of medical problem. Anyway, infers prediction content. This is a very general kind of inference. This would apply, for instance, to the so-called generative AI. Recommendation, here we are in the domain of, for instance, of targeted advertising, or decisions that can influence physical or virtual environment. Sorry. So it is not a definition that is very easy to be applied. You may wonder whether the systems doing statistical predictions in banking, for instance, are or not AI systems. You may wonder whether expert systems that include for instance, imagine a system that includes a lot of rules and that determines how much a person is supposed to pay in taxes, or whether a person has the right to a certain benefit. Do they fit within this idea of AI? Yes, the system is autonomous in the sense that it applies the rules by itself, but the rules may have been inputted by somebody. This is different from a system that is able to build by itself its own rules, its own model, such as a system that relies on supervised learning. We give the system a set of examples, and the system learns a model based on this example, so that the system, on the basis, for instance, of a set of tagged photographs, is able to identify objects in a new image, telling that something is an animal or a man, or is any kind of animal. So what was I saying? I got a bit distracted. Anyway, so it is difficult to determine what fits within this definition. The European Commission has now produced a very large document, which I have not yet read. I think it's 100 pages or something like that, where they discuss the definition of an AI system. But we should not be too worried about that, I think, because for the purpose of the AI Act, what matters is not so much whether a system is or not AI, but whether a system falls within the categories of unacceptable, systems that are unacceptable, risky, or systems that are deemed to be high risk. And so the problem of whether a system is AI or not is not likely to have a very large impact, I think, on the practice, but we will see. And then there is a notion of what is a risk, and risk, here the usual notion of a risk is presented, combination of a probability of an occurrence of harm and the severity of that harm. As I said, the notion of a harm in the AI Act is very broad. It is not limited to damage to health, safety, economic harm, but it also includes any kind of negative impacts on fundamental rights or on a fundamental value. This notion of risks also, you may wonder to what extent it is applicable to cases where you have uncertainty, where you don't know, cannot quantify the probability of the harm that is possibly going to take place. Anyway, let us continue and then go into this kind of pyramid that has been, this is an image that has been provided by the Commission. Sorry, what do you do usually? Do you keep going until the end of the 2 hours, or do you have a kind of interruption? Hello?
We go through the end.
Sorry, I cannot hear you. Okay, so we continue until the end without any interruption. Is okay for you, for everybody?
Yeah.
Okay, perfect. So let us now go to the core of this idea of high-risk regulations. Certain systems are deemed to have an unacceptable risk, and these are listed at Article 5. This is a very long article, very complex, because there has been, especially because there has been a kind of bargaining between the Parliament and the Council, where the Parliament wanted to expand the range of systems deemed to be prohibited systems, while the Council wanted to restrict this category, in particular with regard to the issue of facial recognition. So what are these kind of systems that are deemed to present an unacceptable risk and therefore are straightforwardly prohibited? The reference is to those systems that cause manipulate individuals, causing serious harm to them. Also, this is a category that in a subliminal way, without the individual being aware that this is happening. This is also a difficult category to be identified. You may imagine a system exploiting the feelings of people or their weaknesses, for instance, propension to gambling or to engage in dangerous behavior in order to sell products or to manipulate people into or to frauds or other kind of outcome of this kind. Then there is a prohibition of social scoring. This is, I think, the kind of prototype that the legislator had in mind is the social credit system that apparently is being used in China, when people, depending on what they do in different contexts of their life, may incur penalties, which is points being detracted from the social score, or rewards, points being added to their social score. For instance, a penalty may be delivered if I do not pay my debt, or I don't appear in front of the court when I'm required to do that, or I cross the street with the red sign, I violate the street code, or possibly I engage in activities, political activities that are not approved. And on the opposite, if I do any kind of virtuous behavior, my score goes up. The idea is that in this way, everybody knows the value of the people with whom they interact, and the problem of social trust is solved, and people are incentivized to behave virtuously in order to get as high a credit as it is possible. Obviously, this approach looks a bit frightening, because people would not feel free to behave as they feel like, and can be pressured in multiple ways to engage in whatever is desired by those that have control over the system. And in the AI Act, you may have the prohibition of having systems that collect scores from the behavior of the individuals in different life domains, and they integrate this score into a rating that is then associated to the individual concerned and is used to assess them and behave towards them. Obviously, also in our countries, in European countries, we have something similar to this mechanism of scoring. We have credit scoring, on the basis of which you may receive or not credit. And we have also quite comprehensive system of scoring, but in the private sector especially. Consider the case of those individuals working in the domain of the gig economy, for instance, for the drivers of Uber, or the food people engaging in food delivery. These people are in this monitored, and they received rewards and sanction measured in according to the impact on their score, and this determines their future opportunities in their work. So it's not a comprehensive system, it's not directly prohibited by the Act, but still there are some similarities that would require care in assessing the lawfulness also of this kind of system, even though they are not prohibited by the AI Act, because the AI Act refers to the integration of information coming from different domains of life. And then we have the issue of facial recognition. Facial recognition was there was a big discussion, and the discussion concerns facial recognition in public real-time facial recognition in public spaces. So this would be that when you walk in when you walk in the street, there is a system that is able to identify your face and the face of everybody else, and then by linking your face to a catalog of faces, where faces are associated with the identity of the persons, of the people involved. So if this kind of system was generalized, you can imagine not being able to go anywhere without being subject to this kind of surveillance. Obviously, there is also such a system can also have useful deployments, in particular in the context of law enforcement, when the issue concerns, for instance, preventing, identifying terrorists that are trying to engage in an attack, or also victims of violent, potential victims of, how do you say, other serious authors or victims of serious crimes. And so there has been an interaction between the parliament and the council. The parliament wanted, as I said, to limit the deployment of facial recognition on real-time facial recognition on public spaces. And the council arguing instead for expanding this kind of the use of this system when in the context of crime, preventing and prosecuting crimes. And the compromise is to be found in Article 5 of the AI Act. This, I think we can stop here concerning the kind of systems that are prohibited, applications that are prohibited, since they are considered to have to entail an unacceptable risks. So just to summarize again, so the prohibition concerns systems that deploy subliminal techniques to manipulate or deceive individuals, causing a serious harm. Systems that profit of the vulnerability of particular categories, again, in order to to cause a significant harm. Social scoring system that classify or evaluate a natural person based on their behavior, inferred in their behavior in different social contexts. And then systems that engage in real-time face identification with the exception, certain exception concerning crime, preventing and prosecuting serious crimes. So this is basically the kind of context. And then we move to the level 2, which is the real focus of the AI Act, which concerns systems that are deemed to entail high risk. What are these systems? And here we have a kind of a complex distinction. There is a list of systems or categories of systems that are deemed to be high risk, and they are included in Annex 3 of the AI Act. And these are, for instance, I think we are going to have no. Okay, and then maybe I'm going here. High risk. Okay, we have this is Annex 3, not 2. Standalone system, biometric identification, categorization of natural persons. I think it's Annex 3 now. It's not Annex 2, but it doesn't matter. Management of critical infrastructure. Imagine the electricity grid, or also transportation, education or vocational training, employment, work and manage and access to self-employment, essential private services, among which there is also the issue of the banking and health services, law enforcement, migration, asylum, border control management, administration of justice, and democratic processes. So if you go through you will find that these systems that operate within this domain, then there is a more specific, there are further conditions that are included in the description of the high-risk system in Annex 3, are subject at the core of the AI Act, which establishes requirement for this system, we're going to see which one, and a certification procedure. They cannot be put on the market unless they have followed, their development have followed certain process and methodologies. They have been, their risks have been identified and mitigated. And finally, these risks, the remaining risks, have been assessed as acceptable. So there is this list in Annex 3. And then there is also the idea that so there are two, this is a bit complex, but there are two categories of high-risk system. Those listed in Annex 3, new applications of AI, and then risky products that are already subject to third-party certification. And they include machinery, toys, lifts, radio equipment, personal water, medical devices, etc., etc. All these things, to the extent that they include elements of the AI, will also be considered to be high risk. And therefore, their AI component is going to be subject to the requirement established in the AI Act. The difference between these two categories, I'm sorry if I'm going to go in bit in the detail, but this gives you an idea of the machinery that is introduced by the AI Act. So the main difference is that while for the standalone system, the system in Annex 3, the certification has to go on by following the procedure established in the AI Act, for this other system, the systems that are already governed by safety regulations and that are subject to third-party certification, the control over the AI system may be embedded in existing procedure. For instance, in the procedure for certifying medical devices, if a medical device, assume that there is a medical device that includes an AI component, then this medical device is going to the procedure for the conformity for medical devices, and within this procedure, also compliance of with the AI Act is going to be considered. On the other hand, if you have a system that a new AI system that is not governed by existing safety regulation, consider, for instance, a system that assesses the creditworthiness of those who make a loan application to a bank, then this system is going to be evaluated based on the procedure established in the AI Act, because there is not an existing procedure for the conformity of this system. So this is the basic distinction in the regulation of AI system, high-risk system in the AI Act. Okay, this is what a new element of complexity in the AI Act. Those systems that are listed in Annex 3 are the ones that I mentioned before, that is biometric identification, critical infrastructure, system used within education and vocational training for selecting or evaluating students, etc. These systems are considered high risk, but this is a rebuttable presumption. That is, the developers of this system can show that the system, in reality, given the context in which it is used, does not present a really high risk. Let me give you an example. For instance, in the judiciary, the application for the judiciary is considered to be high risk. But for instance, an information retrieval tool for judges, even an intelligent one that relies in some machine learning methods, even that, for instance, engages in matching the representation of the query of the users and the representation of the text to be looked for instance, by generating different mathematical representation, different embedding for the two representations, may not be considered to be high risk, given that it does not really affect the functioning of the judiciary. And in this case, it may not have to go through this procedure on the basis of this exception that has been introduced by the parliament. Okay, and then, but then what are the requirements that a system that is deemed to be a risk has to respect? And you can find them in the rules included in Article 915. And these are quite technical rules. You may wonder whether legislative instruments such as the AI Act was really the place where to put this kind of detailed technical rules. But no, there they are, and we have to accept that. So a system, a mechanism must be put, a procedure, an administrative procedure must be put in place to assess the risk of the system, identify the risk, and if a risk exists, mitigate it, reduce it to the minimum. A mechanism must also be in place for data and data governance. So a procedure for checking what data are used by the system, and to ensure that these data are accurate, relevant as needed. Then there is the aspect of preparing appropriate technical documentation and keeping records on the behavior of the system. So this is linked to the idea of accountability. Not only those developing a system must take care that all precautions are taken, but they should also be able to show that this is really the case. This is the idea of accountability. You have to, the concept of accountability plays a central role in the recent technological regulations at the European level. What does it mean, accountability? It means that the deployers of systems have themselves to take care that this system work appropriately. Also, that this system do not cause harm with regard to all the interests to be taken into account. And so it is not sufficient that they passively comply with the law, but they must identify themselves the best way to achieve the goals established by the law. And moreover, they must be able to show, upon request, that they did indeed engage in this activity. So take proactive initiatives and be able to show that this was the case. This is the two prongs of the idea of accountability. Transparency, a provision of information to the users. So to the extent that is possible, the user should be able, the deployer of the system should be able to know what the system is doing, being provided appropriate information. There is the idea of human oversight. This is an important concept, but also a difficult one. This should be possible that this is established in Article 14 of the AI Act. It should be possible for a human so to use the words in the AI Act, high-risk AI system shall be designed and developed in such a way that they can be effectively overseen by natural person during the period in which they are in use. So this is quite difficult because this system gets more and more autonomous as AI develops. But the idea that it should always be possible for humans to control what this system are doing in order to, especially in order to prevent and minimize whatever risk this system may entail. Accuracy, robustness, and security from cyber attacks. So the provisions of on high-risk system are directed mainly towards developers of such systems. So the target is the developer, or those anyway who put these systems on the market. In the AI Act, there are two main figures that are two main kinds of entities that are the addressees of the provision of the Act. We have the developers, those who build or put on the market the Act, and then the deployers, those who use the Act for non-personal purposes. But the main provision of the AI Act are directed to the developers. So we have the providers. Here we have the notion of provider. That means natural legal person, public authority, agency, or other body that develops an AI system or a general purpose AI model. Then we are going into the general purpose AI model. This is something we're going to say something later. And places it on the market or puts into service. And then we have the deployer, a natural legal person, public authority, agency, or other body using an AI system, except where the AI system is used in the course of a personal non-professional activity. Just to distinguish the two roles, imagine a company that provides a system for, I don't know, evaluating applicants to job position or for assessing creditworthiness of applicants for loans. And this entity would be the provider, while the bank or the company using the system for making appointments or for granting loans will be the deployer. The risk management system, so the developers are required to set in place a system that controls the functioning of the AI system throughout its life cycle. So the control over the risks that an AI system presents is not limited to the stage before the system is put on the market, but continues when the system is used, and should take into account also the risks that are discovered also after the system has been already deployed. So the responsibility of the developer continues after the system is put on the market. There is a lot of technical documentation. We don't need to get into this aspect that has to be produced concerning the system. There is controls. So one problem of the AI Act is that a lot of documentation has to be provided, and we will see in the application of the Act whether this requirement to produce documentation provides. Sto facendo lezione, arrivo alle 4, devo fare lezione alle 4. Diglielo. Sì, sì. There is this quality management system that needs to be put in place system is not really a computer system, is an organizational procedure for ensuring the quality of the system. And now we're going to the important step, the end of the process, which is the conformity assessment. So we have, I am the developer. I have built an AI system, for instance, a system that evaluates the creditworthiness of people asking for a loan. And I provide this service to banks, for instance. I make this system accessible to banks who want to use it. The system has been developed. The system has complied with all the requirements that you can see here. So we have evaluated, identified whatever risk the system may present. We have estimated the seriousness of the risks, taking into account their likelihood and their seriousness. The importance of the risk, taking into account the likelihood and their seriousness. We have identified ways to mitigate those risks, and we have fixed the system accordingly. And we have set up the mechanism, the procedure for having control, human oversight over the system, quality controls. At this point, the system has to be assessed to check whether every requirement has been complied with, and whether the remaining risks are overall acceptable. At this point, conformity assessment is made. The system is registered in a database, and a declaration on conformity is signed. If there are changes, then a new evaluation of a system has to take place. The issue is who is going to sign this conformity assessment. And here there is a further complexity of the AI systems. Under certain conditions, in particular where there are harmonized standards that tell how a system should be built, in this case, it is presumed that a system that corresponds to these standards is okay. It has only acceptable risks. And the conformity assessment may be signed by the developer himself without engaging with a third party. In other cases, there is going to be a third-party assessment, and there will be private bodies. This is an important aspect of the AI Act. The enforcement of the Act is largely delegated to private bodies, even though these bodies are going to be to private persons, even though these private entities are under the control and the oversight of public authorities. What are these private entities? First of all, the developers themselves that have to sign, my system is okay. It only presents acceptable risks, and it complies with all the rules of the AI Act. Or by a private body. It's called a notified body. That is a private entity that has been somehow certified by public body, that is called the notifying authority, that has been certified as having the capacity to provide this kind of conformity assessments. Therefore, the company, in certain cases, especially when there are these kind of standards approved by the Commission, can self-certify. In other cases, the company, the developer, has to go to the notifying authority, and the notifying authority will certify that the AI system is okay. Okay, there is one further. Then I go into the I go into the issue of the institutional structure. Are there any questions? It is very complex. I'm sorry, a bit boring. The AI Act is a piece of complex administrative regulation, and no, there is no other way that to go into its detail if you have to understand how it works. Any question from the public?
I have a curiosity, if I may.
Yes, please.
So what happens, for example, to AI systems that are developed abroad, let's say overseas, where this AI Act doesn't apply? So these systems didn't go through all these processes. So are we allowed in Europe to use them, or are there any limitations at all?
For this purpose, we have to consider the regulations on the scope of the act. On the Article 2 of the AI Act, and the Article 2 says that the AI Act also applies to provider placing on the market or putting into service AI system or placing in the market general purpose AI models, irrespective of whether those providers are established or located within the Union or in a third country. So in principle, anybody offering AI system, so offering services of AI systems in Europe should comply with the AI Act, even if the system is located in the United States, in China, whatever. So this is similar to what happens also with data protection law. So whoever is processing data that in order to provide a service in the European Union is subject to the GDPR, to the data protection regulation, and the similar idea is also within the AI Act. To what extent will this be implemented is another matter, but this is what in principle is established in the
that's clear, but does it mean that if these companies want to offer their systems, their AI-based systems in Europe, then they do have to do all this sort of
yes, they should do all of these
they are in charge anyway, even though in the US, for example, they don't have to.
Yes, if they want to provide AI system, it's the same also with data protection. Now, if a company, American company, wants to provide service to collect or use data for providing services to European citizens, they have to comply with we can have a look at the, sorry, I don't have now the GDPR under my screen, but if you go into the that is going to the, if you go into the GDPR and you go GDPR X, just a second. If you go into the GDPR, let me go there. GDPR, and it's at the beginning of the GDPR. Now you have to look into that. Sorry, but the same idea is expressed in the GDPR. Let me go into the GDPR. I'm not finding it now because overview. Where is it? The text. Anybody of you has the text of the GDPR with you? If you look into article, must be article 2 again. Material scope. No, it's not material. It is. Let me see. No, what is this thing? Definitions. No, is article 3. I'm not able to click. Territorial scope. Okay, here we have. This regulation applies to the processing of personal data. in the context of the activity of an establishment controller. This regulation applies to the processing of personal data of data subject to are in the union by a controller or processor not applied on the union, where the processing concerns the offering of goods or services in the union, or the monitoring of the behavior of that takes place in the union. So something similar. There is the idea that when a service is provided within the EU, it should comply with the regulation of the AI Act, an AI service. So it should be the same idea that is found on the GDPR. This is the idea to subject to the European law also services that are provided online to people, to entities located in the European Union. The basic idea is the same. Then we will see to what extent this is going to be effective. But this is the idea.
Thanks.
I have a different question related to the existing system, a system already already running. Do they need to be to have an assessment, a compliance assessment as well?
I don't know. I think so, but I'm not sure. I wanted to check for that, but I couldn't find precise information. I think there may be precise information. I think so, because the idea of leaving 2 years for the entry into force of the AI Act is also linked to the idea that existing systems should also be brought into compliance with the Act. But I want to investigate that. If anybody knows, I had the same curiosity a couple of days ago, but I couldn't find a precise answer, so this is my assumption.
I wonder if it is only the assessment, compliance assessment, is necessary only when you made updates, important updates or something like that.
If you made updates, a new assessment, if a system has already been assessed and there are changes, then a new assessment is needed. If a system is already in place, so the issue would be, can you continue to deploy it without making an assessment of its conformity with the AI Act? I would say no, but I need to check. I'm not sure on that. I think that if anybody wants to make a small
I think that
inquiry,
AI systems already placed on the market should comply with the AI Act by August 2030.
Yes. Is it? I'm not so sure. I know that there is this deadline of August 2030, but I'm not sure that it is. Should be the last article. Let us check. But it should be the last article of should be the provisions on the time of the entry into force. Should be the last. Let me check. Should be the last provision in the Act. If anybody is quicker than me. Final provisions, let us go there, entry into force and terms of application, let us see.
It seems there are different deadlines to comply to the AI Act according to the level of risks.
Yes.
Yeah, but this is a different...
Article 111 is about AI systems already placed on the market.
Okay. Article, which is the article?
111.
Article 111. Maybe you are right. Yes, I didn't check that, but maybe you are right. So if an AI system, if this is true, it would make also sense to some extent. 111 already placed on the market. Okay. This is true. So I learned something new myself. He said, without prejudice to the application of Article 5, so prohibited systems are still prohibited. AI system which are component of a large, but this is large-scale IT system. This is a different category. Let me place my before. Sorry. Without prejudice, it's very complex. This text is terrible, I think. It says, without prejudice of the application of Article 5, the prohibition, this regulation shall apply to operators of high-risk AI system other than the system referred in paragraph 1 of this article that have been placed on the market before Article 2, 2006, only if, as from the date the system is subject to significant changes in their design. In any case, the provider or deployers intended to be used for any public authority shall take the necessary step to comply with the requirement and obligation of the regulation by August 2030. So we have solved the mystery. So these systems can stay on the market. So if they are put in use before 2026 and they go through the certification procedure only if there are significant changes in their designs. However, if they are used by public authorities, they should be compliant by 2 August 2030. So I was wrong, and thanks for correcting me. This is the right solution.
Thank you.
So now we have solved the mystery. Thank you for your help.
Sorry, I have a question, if I may.
Yes,
Yes. Does the AI Act provide say something about the quality of data used for training
yes.
AI model?
Yes, but not much. But there is an article on data quality, and we have to go back where we have we haven't gone yet. I think we have to go through the general. We are not going into general purpose model, generative AI. Let us just focus on high-risk AI systems. There is Article 10, which addresses data and data governance, where it is said that high-risk AI systems which make use of techniques involving the training of AI model with data shall be developed on the basis of training, validation, and testing datasets that meet the quality criteria referred in paragraph 2 from 5 whenever such datasets are used. And then there are some training, validation, and testing datasets shall be subject to data governance management, etc., etc. And there are quite a few specifications, not very so. Data should be training, validation, and testing data shall be relevant, sufficiently representative, and to the best extent possible free of errors and complete in view of the intended purpose. They shall have the appropriate statistical properties. So it's a bit, I don't know, that there are these kind of rules that are a bit obvious, kind of standard requirements. To what extent? So, but if you are interested into that anyway, you can find. We cannot go into the detail here. But if you go into Article 10, you can find a description of the requirement for data governance. I think this is a bit a problem of the AI Act. This kind of requirements are obvious if you are somebody that is working on, it's a kind of standard, good practice with data, but you can find it also specified to some extent in Article 10 of the AI Act. Yeah. Oh. Okay. If there are no further questions, we can continue and have a quick look at Article 27, where you have the rights of deployers. Sorry, the rights of deployers. When you have the I'm losing myself. The fundamental right impact assessment. This is a new rule that was introduced by the Parliament, the European Parliament, and which does not concern developers. Also, developers have to take care of the fundamental rights in the context of the risk assessment of high-risk systems. But for certain AI system, also deployers. Remember, the deployers are those who use an AI system for the purpose of for a non-personal purpose, such as we said, a bank using or a lawyer using an AI system in the course of his activity, or a bank, or whatever. And the school deployers deployers. So here there are who are subject. Certain deployers have to do fundamental right impact assessment, which deployers deployers that are bodies governed by public law, or private entity providing public services, or also private deployers of certain kinds of AI systems. And these are basically, if I remember well, those providing creditworthiness assessment, and those being used in schools to select and assess students. So have to perform an assessment on the impact of fundamental rights that the use of such system may produce. But then there are all those who are governed by public law. So when an AI system is used in the, for the purpose of law enforcement, or for the purpose of also in healthcare by a public hospital, apparently this assessment has to be undertaken. And the idea is that there should be an assessment of whether this system, the operations of this system, are likely to interfere with fundamental rights. And also in this case, mitigation measures have to be taken if this is the case. This is a rule that was introduced by the parliament, and then it was restricted by the... I think that our time is elapsing, and I couldn't, but we are going to do that when we meet again. We have not been able to enter the discussion of general purpose AI, or we can also say generative AI system, because the two categories almost overlap. The parliament, when the AI Act was being discussed, it was already in the stage where the parliament and the council were exchanging texts and amendments. At that point, there was a revolution that the generative AI came emerged suddenly, and it was a shock for everybody. We have AI systems that are able to answer any kind of queries, produce text apparently in a coherent and intelligent way, being deployed in a vast amount, in the vast domains, but they didn't fit the basic idea of AI system as understood in the Act, which was focused on the idea of specific AI system having a specific goal, be it assessing creditworthiness, assessing candidates for a job, making medical diagnosis, recognizing images. We have systems that can do many things, and then therefore don't fit easily into the kind of assessment that were included in the AI Act. So very in a hustle, very rapidly, some rules were introduced for general purpose AI system. Whether this rule makes sense or not is still open to debate, but we were going to look into that when we meet next time. So thank you very much for listening to this presentation. I'm sorry if it was not so clear, but it is in part due to my defects, but also maybe in a larger part due to the nature of the AI Act, which is a very complex piece of text, and very complex also. The implementation of the Act will also be quite an engaging enterprise. So bye-bye to everybody, and see you soon again.
Thank you.
Thank you so much.
Thank you.
Thank
Bye.
you.
Bye.
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 Bye-bye.